Good morning, Norris.
Hey, Judge, I'm gonna start to bring them out now, okay?
Okay, just let me know when you're ready. Good morning, Miss Falk. I hope you're well today.
Same.
Thank you.
Yeah.
So we'll get started, everyone, as soon as courtroom 2 is ready.
Good morning, Judge Morrow.
Good morning, Miss Lewis. How are you today?
Did you get the recommendations? Because I was out yesterday.
Yes.
You got
Ms.
the
Falk
announcement?
sent them, and the recommendations were sent to me also. So yes, thank you.
Okay.
Is this Miss Strong?
No, this is Miss Lewis.
Okay, let me sorry. I'm terrible with faces. Miss Lewis, let me go ahead and forward that to you if you want me to send it over.
Lewis, now. Danny Williams. Third row.
Miss Lewis, do you need the recommendations from Ms. Falk? Or do you have them?
Cameron
You are
Taylor,
mute, Miss Lewis.
third row.
I was out yesterday. They may be on my email. I haven't got a chance to check them. I'm about to check them now. But if she has them, she can send them to me.
I'm sending them over now.
I appreciate that. Thank you.
Third row. Yeah. Third row. Gregory Allen. To the third row. Odin Brown. Third row. Hawkins. Third row, just tighten it up, fellas. Kelly. Third row. Norwood. Third row. Perkins.
It's in order, that's.
Perkins. Hey, sit right here.
Mr. Jen. Yes, ma'am. Do you have any?
No.
Yeah, the only folks I'm not ready with is Daniel Williams, Greg Bowers, Olivia Brown. If it goes for anybody else.
We got a contact them?
Yeah, I just haven't talked to those three folks yet. Everybody else, I mean.
And who else?
What was the last person? Olivia Brown. Yeah. It was great. I mean, Daniel and Gregory Allen.
Good morning, Your Honor. Good morning.
Good morning,
everyone.
Officer Milton. Hope you're well today.
Yes, sir, you too.
Thank you.
Well, we can start with.
Let's see. Good morning, Mr. Kozicki. Who are you here on this morning?
My apologies, Your Honor. Good morning. Miss Selena Brown.
Okay, I'll just make a note of that so that they know that you're here for her. Thank you.
Thank you, Your Honor. Nice to see you this morning.
You also.
We can start in courtroom 2 with position 14, Jeffrey Sparrow.
Sparrow.
And good morning, Ms. Vigiletti. Let's see. Do you need me to arraign Mr. Sparrow this morning, or are you going to file a waiver?
Mr. Sparrow, actually, we filed a waiver on February 1st. This is his second time at SAP.
Okay, and so this is just a bond modification request this morning?
Yes, Judge.
Okay, let's see. Who do we have on from pretrial? Ms. Tyson, are you with me? Good morning, Mr. Graham. What is the current bond in the matter?
Good morning, Your Honor. I have a $6,000 surety bond. It's $3,000 on each count. Battery, family violence, and cruelty in the third.
I'm sorry, I see it's a cash bond. Is it a surety bond?
It's a cash bond only because he bond forfeiture before Judge Edie, and Judge Edie's asking for a cash bond.
Thank you. My apologies.
Okay, is there a reason that this should not go? My normal practice, as you know, Ms. Vigiletti, is if another judge has set the bond, that I send it back to them to see if they want to modify the bond. Is there any reason that I shouldn't do that in this case?
Yes, Judge, I don't see a reason other than, Mr. Sparrow came before us on February 1st and he's not received any hearings or spoken with anybody since then, and it's been, about 7 weeks. So because I don't actually know who or what prompted him to be back on SAP, but since he was back here, I thought I'd make the request, but we can certainly send him back to the trial judge as well.
Normally, if there's an FTA, I have that on the calendar. I don't seem to have an FTA on the calendar for Mr. Sparrow.
Because Mr. Sparrow's been on several SAP counter, and the litigation manager for Judge Edie, it was sent back for jail jury. And I guess she hasn't set the calendar yet for Judge Edie for his jury trial calendars. I don't know why it came back to us unless she sent it back to us for a reason. Maybe he was going to enter a plea. I don't know. But it has been sent to Judge Edie, and Judge Edie sent it back for whatever reason. I don't know.
Okay. And is it Ms. Falk, do you have an input?
Yeah, Yes, Your Honor.
Oh.
I'm showing that he actually failed to appear on two separate jury trial dates in front of Judge Edie, both on February 8th of 2022 and April 13th of 2022. I will reach out to the, due to kind of the timing of when this all happened, will reach out today to the litigation manager and the solicitor generals who are on that team to make sure that it is set at the earliest possible date.
Okay. And if they did want to send it back to SAP for one of us to hear it for the bond, I'm happy to do that. But Ms. Falk, if you will make that inquiry for me, and let's put Mr. Sparrow back on an add-on for Thursday. And if they want us to hear him, then then we'll hear it. If they want it to come back to their court, then we'll send it back. Okay.
Yes, Your Honor.
Thank you, Judge.
All right. So we'll see you back on Thursday, Mr. Sparrow.
Next, we go to position 18, Trevor Woodard.
This will be a non-negotiated plea.
Yes, Judge.
Good morning, Mr. Woodard. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Yes, Mr. Graham.
Thank you, Your Honor. So this incident took place on March 3rd, 2024. Law enforcement conducted a traffic stop, vehicle with no plates. When he approached Mr. Woodard, he didn't have his license. He said he had rushed out of the house. There was no paperwork on the truck because he had recently bought it from someone in Mississippi. He also gave the officer a false name. Among the possessions found in the truck were a wallet, which contained debit cards from a Mitchell Duggan. And the truck came back to be a stolen vehicle. The state's recommendation, Your Honor, in this case on count 1 of theft by receiving stolen property, 12 months, served 90 days, credit for time served 17 days. That's from March 3rd, 2024 until March 19th, 2024. Violence probated, anti-theft course, no further contact with Mitchell Dugan. Count 2, 12 months probation concurrent with count 1, no further contact with Jermaine Maddox. Count 3, 12 months probation concurrent with count 1 and 40 hours of community service. Your Honor, the recommendation is based on the defendant's history. He's got 11 cycles out of Mississippi, 7 cycles out of Florida, including a grand theft auto and obstruction charge conviction. 3 cycles in Tennessee, including the theft of property and a burglary of auto, also a guilty plea. 1 cycle in Alabama, 2 here in Georgia. One of them is entering auto with intent to commit a felony and theft by taking, in addition to this, theft by receiving stolen property, giving false name, and theft of lost and mislaid property charge. So I guess if the defense has I don't know what part of the conditions or the plea they may be in.
Mr. Graham, what were the dates of those previous convictions? Do you have those?
I have the year, but I can look back for you. The grand theft auto in Florida was 2018. The theft of property in Tennessee was 2023. And here in Georgia, the entering auto was also 2023. I can pull the dates.
Oh, no, you're fine. And those are all convictions?
The cycles in Florida and in Tennessee are convictions.
Okay. Ms. Vigiletti?
Yes, Judge. Today, Mr. Woodard would like to enter a plea, but we wanted to discuss the possibility of time served on the jail time. Mr. Woodard tells me that, you know, he purchased this vehicle from Jermaine Maddox, he was told, oh, I don't have the title, but I have the proof of sale and I'm gonna put it in the mail to you. And that's the same thing. It's just as good. And so, you know, the cards found in the truck also belong to Jermaine Maddox, who is sort of an acquaintance of an acquaintance. Mr. Woodard made a bad mistake not getting that paperwork before he drove off with the car. But, you know, he handed the guy $1,400 cash. The plan was to come to Atlanta. He and his wife had recently lost their job. They were coming to Atlanta in advance to get new jobs. They had been working, both working 2 jobs in a factory and at Waffle House. They lost their factory job. They had decided to buy this car, come to Atlanta together, to set up a new life for them and their 6 kids who they actually left behind. They're setting up a life in Atlanta for their 6 children. You know, it's a bad mistake. He handed this guy $1,400 before he had the paperwork. And the guy promised him paperwork, and of course, he was very surprised to find out the car was stolen. You know, he did commit theft by receiving by not being careful, but he was also swindled in this situation. And so in light of that, in light of the fact that, you know, he's going to be doing probation, taking this anti-theft course, will have no contact with these people. We're just asking the court to consider time served on the jail time. He has been here 17 days as of today. He did give the officer a fake name to protect his wife. His wife had a warrant, and once she gave the correct name, he gave the correct name, and she is still incarcerated, and he would like to get out, get on his feet, get some housing. They have 6 children together. He'd like to set up some housing for his 6 kids, you know, while she's handling her legal troubles.
And Your Honor, if I may, I did neglect to sound.
Vigilante. Because it sounds like the arguments that you're making is that he's not guilty, but he wants to plead guilty. And part of pleading guilty, in my mind, is that you take responsibility for what you've done. It might be a different story if he didn't have the previous convictions, but if he's not guilty and you're telling me that he doesn't believe he's guilty, I'm not going to accept a guilty plea from him.
I'm sorry, Judge. I think that's maybe my accidental mischaracterization. He fully, when we spoke yesterday, he fully took responsibility. He did not have the proper paperwork when he purchased this car that he should have had, and that is a bad mistake on his part. That is likely my mischaracterization, just based on empathy for, you know, understanding he handed someone cash and trusted the wrong person. He bought a car that he did not have paperwork for, and that, you know, of course, when you don't have the paperwork, it could be stolen, and that's your responsibility.
Does he have proof that there was an actual transaction?
My understanding is the transaction was cash. Friend of a friend, very quick interaction.
Mr. Graham?
Yes, Your Honor. First, I would like to, I neglected to sound for the victim, so if we can sound for Mitchell Duggan in accordance with Marcy's law.
If Mitchell Duggan is on the line and wishes to address the court, now is your opportunity to do so. Okay, Ms. Vigilante, that doesn't, I appreciate your argument. It doesn't ring true to me. If he wants to plead guilty, then he will accept I will accept the recommendation of the state.
Understood. Just mute us real quickly. Okay, Judge, Mr. Woodard would like to proceed with the plea as negotiated today.
Okay. Anything further from anyone?
Your Honor, we'll
If
just
not-
have the defense stipulate to factual basis, venue, and identification for purposes of the plea.
We do.
Mr. Woodard, it's my understanding that in case 24 CR 001-006C, you wish to plead guilty to theft by receiving stolen property, theft of lost or mislaid property, and giving false information to law enforcement. Is that correct? Are you under the influence of any drugs or alcohol this morning? Answer verbally for me, sir. You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Well, I'll accept the plea. The court sentence will be for count 1, 12 months to serve 90 days, credit for time served 17 days, balance probated, an anti-theft class, and no further contact with Mitchell Dugan. For count 2, we'll run concurrent 12 months to serve 90 days, credit for time served 17 days, balance probated. And for count 3, 12 months to serve 17 days, credit for 12 months to serve 90 days, credit for time served 17 days, balance probated, and 40 hours of community service. When you complete the terms of the probation, Mr. Woodard, I'll have it go to a non-reporting status. So the sooner you get the terms done when you get out, the sooner you won't be on reporting probation and won't have to pay those fees. Good luck to you, sir.
Thank you, Judge.
Next we have, Your Honor, is add-on position, I'm sorry. Ms. Marks, position 8. Brianna Marks, position 8.
Okay. And do you also have their position 1, Selena Brown?
Yes, Your Honor, I do have Ms. Brown here. You would like to do
Okay.
her first?
No, we can do since Ms. Marks is already there. I'll go ahead and do her, but let's do position 1, Ms. Brown next, okay?
Yes, Your Honor.
Thank you. Good morning, Ms. Marks. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Your Honor.
Yes, thank you, Ms. Marks. Let's see. Who represents Ms. Marks?
I represent Ms. Marks, Your Honor. I spoke to her yesterday. Good morning.
Yes, good morning, Mr. McLean. What are we doing with Ms. Marks today?
Well, I put that down for a counteroffer, but we haven't talked with the state yet. I would like to explore a diversion idea with the state.
Ms. Falk?
So
I'm more than happy to hear PD McLean out. So I'm fine with listening to whatever argument he has to make offline. So he can give me a call. That's fine.
I'll
Okay.
do that. Thank you.
All right, we'll come back to you, Ms. Marks.
Next, we have position number 7A on the add-on calendar, Cameron Green.
He just stepped out. Was that Cameron Green?
Okay, I would like to go ahead and take position number 1, this Selena Brown that's in front of me on the add-on calendar. Yeah,
Yes,
is that-
Your Honor.
Okay, thank you. And what are we doing with Ms. Brown this morning?
Good morning, Your Honor. Tony Kazicki on behalf of Mrs. Brown. She was arrested on an FTA. My understanding is these charges stem from an incident in 2022. The accusation was filed in late 2023 or I guess August of 2023. And at that point, the notice was sent to an address that was very old. It in fact wasn't the address at the time that she was released. And I'm not sure of where it came from, but that's the reality of what happened. She lives in Lilburn with her mother and her children. She was picked up on a traffic violation and they found this FTA warrant. We're looking to address it. She was retained counsel. I understand. We're looking to complete the case at this point, but at this point, we're looking to secure her release. We would ask, I see that no, at least from my review of the record, no bond forfeiture proceedings have been initiated. We'd ask to reinstate bond, understanding now that she has representation throughout the rest of the proceedings. She is here to address them. We have filed motions. We are prepared to waive arraignment. I just need to speak with her briefly. And with that, we'd ask to reinstate the prior bond.
And Ms. Falk, is this your?
Yes, Your Honor, it is. It shows that she failed to appear at plea and arraignment December 7th of 2023. And let me just, make sure. Yep. And I can't really respond to the address issue because I haven't heard an address yet. So the state would ask that this case go back before Judge Roth for addressing the bench warrant.
Your Honor, I could provide some context. The biggest issue for us is that she has young children. She lived in a home with her young children, herself, and her mother, who has some health issues. Upon her arrest, her mother has now been admitted to the hospital, and her children were left kind of without care at the moment, but they do have family that has taken over. That family is not kind of in a position where they can raise young children. We're really just looking to get her back. My only opposition to going back and resetting this to another date is that it just extends the time that she's in custody, and her children are kind of at risk, is for lack of a better term. My understanding is this charge stems from a traffic-related DUI case where she was fleeing the scene of some domestic violence. There was a charge of simple battery of domestic violence in conjunction with a DUI, alcohol less safe. From the context that I know at this point, we have not received discovery, filed for it, but haven't received it. She was fleeing from a gentleman that was an ex-partner that was violent on this day and in the past. And in fact, I see that there's a companion case to this that has been joined and filed for another incident of domestic violence that happened 4 days after the arrest. On April 29th, Mr. Drake Myrick was charged and is accused of causing bruising for striking Miss Selena Brown. The incident of this simple battery is alleging that she had made contact with him on that day, but in fact that this was an incident where it's a mother, I believe he's the father of the children, he had abused her that day and she was trying to get away from him. So it's a case where we want to address this, we want to get discovery and close the case, but keeping her in custody is putting her children in my opinion, at risk, because they're with people that they're not used to being with. They're not in a position to be able to provide adequate care for children. They're doing everything they can because they're family and they love these kids, but the mother needs to be reunited with her children. She's been in custody for over a week now, my understanding. We are here to address it. Just going to another judge is going to delay her getting back to her children, Your Honor.
Your Honor, I do have a suggestion. The defense attorney in this case filed his entry of appearance and motions for discovery yesterday at 4:56 p.m. I'm not exactly sure how the state would have even possibly known that he was on this case, much less be able to serve discovery. So I would like this case reset to Thursday. That way the state can provide the defense with discovery that they requested yesterday at 4:56 p.m. and can provide them with the recommendation so they can communicate that to their client, and we can come back on Thursday and address the case.
If I could address that briefly, Your Honor. This family contacted me. The grandmother for Ms. Brown contacted me last week. They don't have very much money. They are poor and they don't have the ability to get an attorney. She sat in custody for over a week and they were desperate to get her reunited. As I mentioned, the grandmother, who is the mother of Selena's mother, who is now in the hospital, is trying to kind of establish care and pass around these children so they're cared for. She called me, we spoke about it, and I said, apply to the public defender. This is what you can do. I'm a private attorney. If you want to hire, this is the cost. They spent all weekend gathering the money from every nook and cranny they could find. And when they paid me yesterday, I filed everything I could immediately. We are trying to get on top of this. I don't need the discovery to address bond right now. We will get there, and we are ready to get there. We're ready to address the case immediately once we get a chance to do it. All we're asking for now is some consideration on bond, with the understanding that it is more so about the children that need their mother than it is Ms. Brown at this point. Ms. Brown needs to be released, and I think that it is very reasonable to understand that there's an address issue, we can provide the address that she is staying at immediately. I'd ask to do it in the chat just to confirm so it's not out to the public, but we can provide the address and get everything in line. We just don't want to delay this till Thursday because that's more time with children away from their mother. And it's already been long enough at this point for a case of a traffic charge where about 18 months after the incident, there was a letter that was sent to an address that she didn't live, and that is the only reason for the FTA. I think the fact that she and her family have retained counsel proves to this court that they are ready to address it, and this FTA issue will never happen again. I don't believe she has a history of anything like this in the past of missing court. I don't know that specifically, but I'd ask the state if they do have information to the contrary to provide that. But it is not an issue that I foresee in the future. We really just need to address her custody today, and then we can address discovery and the remainder of the case as it follows, and we're prepared to do that in a timely fashion. But I beg of this court that we can address custody today so that we can reunite this family and these young children with their mother.
Ms. Falk, did she only miss one court date?
Let me check, Your Honor. Yes, she missed the date on 12/7/2023.
Okay. It's not my normal practice, counsel, but you make a compelling argument. In this matter, I will reinstate her previous bond. You'll have to prepare that for the court. And let's see, you make sure that I'm going to take you on your word that you're going to be her lawyer through resolution of this matter, and that you will be getting the notices on this matter also.
Yes, Your Honor. And if I could be upfront, and if it is an issue, I will just do this pro bono. But the family did make mention that they look to go to the public defender's office. I will work hand in hand if that is okay with Your Honor. If Your Honor says the condition is I have to be on it, I'm on the case, and that's fine. I just would ask if it's still available, if she could go to the public defender's office if their financial resources require it. If that is a sticking point, Your Honor, I'll stay. It doesn't matter.
No, I just want to make sure that she's represented. So if she makes
Yes,
an application for a public defender in the future and she qualifies and you withdraw from the matter, then she'll still have counsel, and that'll satisfy my requirement. But as of today, you're representing to me that you're her attorney, and with the other representations that you have made, I will go against my normal practice and allow you to submit the paperwork so that we can reinstate the bond. Okay.
Thank you, Your Honor.
All right. Anything further on Ms. Brown?
Nothing from the defense, Your Honor.
Judge, I
Alright,
have a question. You talk about reinstate her bond. Her original bond was made through a surety through Free at Last Bonding Company back in 2022. We consider that as a dormant case, so it's not really a good bond at this time.
Okay. Do we have the conditions of that bond?
It was really, according to what I have in my file folder, it was just a surety bond made through Union City Municipal Court through Free at Last Bonding Company. It was on the DUI. Alcohol was a $1,500, and the violation of family violence was $1,000, and she had 2 children. Second degree was $1,000, and that was a $3,500 bond. Even though all the charges didn't get accused in this case.
Okay, so we only have 2 charges, the DUI and the simple battery family violence. Mr. Kozicki, if you will prepare an order for me, I'll make both of those signature bonds, $1,500 for the DUI, $1,000 for the simple battery. Part of the conditions would be a no further contact with, do we have the alleged victim in the simple battery?
Drake
Yes.
Myrick, Your Honor.
And he's on the
And he's-
count for Thursday too.
Yep.
Okay, can you spell that? Can you spell that for me, Ms. Falk?
Drake, common spelling, Myrick, MYRICK.
Okay, no further contact with Drake Myrick, no drugs, alcohol, weapons while out on bond. Got that, Mr. Kozicki?
If I could just note, and I apologize, was it no contact or no violent contact?
No contact.
No contact.
No contact, no drugs, alcohol, or weapons?
Right.
And the one question, did you say a signature bond, Your Honor? Or did you say?
Yes,
Signature-
yes.
Yes, Your Honor. Okay. Thank you, Your Honor. I'll prepare that and submit that.
Signature bond through the jail it will be, okay?
Your Honor, I would request that this be a signature bond through pretrial services, so at the very least, there is somebody monitoring this.
Okay, it will, that's fine, Ms. Falk. It'll be through pretrial level 1.
Thank you, Your
Okay,
Honor. I'll prepare that and submit that to your office.
okay, and that'll go to Ms. Lewis. So if you'll email it to her, she'll get it to me and I'll get it signed, okay?
Thank you, Your Honor.
All right, anything further this morning?
No, Your Honor. Thank you very much.
You're welcome. Have a good day. Good to see you.
You as well, Your Honor. Thank you.
Who do we have next?
Next, we have position 6 and 7 on the probation calendar.
Yes, good morning, Mr. Hawkins. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Yes, good morning, Ms. Allen.
And good morning, Your Honor. Derek Wright for Mr. Hawkins.
Oh, yes, good morning, Mr. Wright.
Good morning.
Your Honor,
Mr.
I'm sorry.
Yes, go ahead. Go ahead.
The defendant failed to pay the probation supervision fees of $360, his Georgia victim compensation fund fee of $81. He has failed to complete the domestic violence counseling program, and he's failed to provide documentation and submitting to a random drug screen. At this time, Your Honor, probation recommends that his balance be revoked. Is 4 months and 28 days remaining on his case. He does not have time to complete the domestic violence program.
Okay, and when was he placed on probation?
Your Honor, he was sentenced to probation October the 10th, 2022.
And I don't think I heard anything about reporting. Did he not report?
No, Your Honor, he missed his probation appointment on January the 9th, February the 13th, 2023, March the 2nd, 2023, and March the 17th, 2023.
Mr. Wright?
Your Honor, my client, when we entered the plea on this case and he went on probation, he had other matters that we also had to conclude, specifically Paulding County, where he went on probation to Paulding County. Currently, there's a hold because of a new arrest recently, but ultimately he had been reporting to Paulding, having it transferred to Fulton for felony probation. And ultimately, I think because he had a few different things going on, sort of lost track of this misdemeanor probation versus the felony probation, as he was reporting to really 3 different entities. But until recently has not been in any trouble for a substantive violation. At this juncture, Judge, we still have to go to Paulding County now. So he will remain in custody. But I would ask, rather than revoke any probation in this case, to simply at this point close this case out. If he needs to pay whatever monies, fines, restitution that were involved, that's fine. But let's close this out so that he can move on to Paulding County and ultimately deal with this new charge in Fulton County, which I expect is going to take maybe a month to resolve. So I would ask not to revoke him for about the 120 some odd days that counsel had intimated to the court is left. There haven't been any issues with the alleged victim in this case, or any of the interactions, any of the what I would call major substantive things that you would want from a probationer. So I would ask at this point if we could simply close this one out and not seek to revoke any time on.
And Your Honor, also, I can understand that the confusion, but the defendant actually did report in office and was told to report back. He reported in December 5th, 2022, and he was told to report back on January 9th, 2022. So he was aware of his Fulton County cases for us to report to our office. And quite a few messages and as well as letters went out to the defendant to report to our office. And so that's why we're here today.
Right, and Attorney Wright, what I don't like about this is that he pled guilty to battery family violence, but he has not done anything as far as the conditions for that. And I understand he might have been in and out of jail or whatever, but I believe that he has to do something as far as the battery family violence charge is concerned. I want him to just be done with this. So I'm going to take probation's recommendation. I'll revoke the 4 months and 28 days and he'll be done.
Yes, Your Honor.
All right. Good luck to you, Mr. Hawkins.
Yeah. Your Honor, that concludes my business. May I be excused?
Yes. Have a good rest of your day. Good to see you, Mr. Riley.
Thank you.
Who do we have next?
We have position number 4, Mr. Floyd.
Yes, this is Mr. McClain's case, and he is on the phone with a client from ACDC right now.
Okay, can we get one of Ms. Vigiletti's cases, please?
Position number 7 and 8, Cameron Green on the add-on calendar.
Also a non-negotiated plea, Ms. Vigiletti?
Yes, Judge. The only issue to discuss today is contact with the complaining witness who is here on the line this morning.
So the only issue is
Contact with Lillian Munoz.
okay, and let's see, is Ms. Munoz with me?
She is. Lily, would you like to unmute?
Yes, I'm trying to figure it out. Sorry.
No problem.
Okay, while I let her unmute, Ms. Falk, if you'll give me the facts, please.
Didn't realize I was muted. All right. So this incident happened on December 11th, 2021. At about 7:59 a.m., Ms. Munoz stated that the defendant physically fought her by grabbing her by the arms and throwing her up against a wall, causing her to damage the drywall in the apartment. She also stated he tossed her onto the bed. Officers did see marks on both of her arms, which appeared as though she had been grabbed. The defendant's history, Your Honor, is he has 6 cycles here in Georgia. It looks like some failure to appears, let's see, as well as possession of marijuana less than an ounce. He did have an aggravated assault out of Gwinnett County that was reduced to reckless conduct and a fray. And let's see, that is all for his history in Georgia. It does appear he also has a out-of-state history. And just pulling that up, it appears he has an offense out of Ohio as well. That was for drug paraphernalia and obstruction of a business, and that case was dismissed. So that is generally his history. The state does not necessarily object to no further violent contact. We were able to reach out to Ms. Munoz yesterday, and she did indicate that they are still together and she wants to have contact, and that was subsequent to our making our recommendation. So we don't object to no further violent contact in this case. That's all for the state.
Okay, as there's no objection, Ms. Munoz, if you would like to testify or add something before this court this morning, I need for you to raise your right hand for me. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down, ma'am. What would you like to tell the court?
We are still in a romantic relationship and there has been no further incidents since that one, in 2021, I think it was.
And you'd like to have contact with him?
Yes.
And has this happened before?
No.
Anything further, ma'am?
No.
All right, thank you for being here. Ms. Vigiletti?
Yes, Judge, if the state is agreeable, then we just ask the court to accept the recommendation of the state, including just a no further violent contact this morning.
Okay, so
And- Sorry, Your Honor.
no, you're fine. Go ahead, Ms. Farr.
I was just going to put the plea rec on the record, Your Honor. It's 12 months to serve, 30 days, credit for time served, 15 days. That's going to be from February 11th to February 12th of 2021 and March 7th to March 19th of 2024. No further violent contact with Lillian Munoz, M-U-N-O-Z, and Family Violence Intervention Program. Count 2, the criminal trespass, is going to be 12 months concurrent with count 1. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We would also, on position 8, enter a null pros.
So this becomes a negotiated plea at this point, Ms. Vigiletti?
Yes, Judge. And we do.
Okay, anything further?
No, sir.
Yes. And I don't know if I've sworn Mr. Green in. If you can raise your right hand for me, Mr. Green. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Mr. Green, it's my understanding that in case 21 CR 000778J, you wish to plead guilty to battery and criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Green. Let's see. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get the terms done, the sooner you won't be on reporting probation and not have to pay those fees, okay?
Yes, Your Honor.
All right,
Thank you.
very good. Good luck to you, Mr. Green.
Thank you.
Thank you.
Who do we have next?
Position 11, Sheila Owens.
Yes, good morning, Ms. Owens. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, yes, Your Honor.
Thank you. Ms. Vigiletti, let's see. Do I need to arraign her this morning or are you going to file a waiver?
I can submit a waiver, Judge.
Okay. Anything further on Ms. Owens today?
No, she wanted to be present, but enter a not guilty plea this morning.
Okay. Ms. Owens, your case will be returned to the division judge and you'll get notification of your next hearing date. You have a good day, ma'am.
Thank you, Your Honor.
Who do we have next?
The rest of the females that I have here belongs to Attorney McLean. So, but right now he's talking to Miss Essober, Destiny Essober. So
Okay.
that's all I have.
All right, so we'll hold. Do we have anyone in courtroom 2 that's that we can take?
Okay, we can go to position number 10 and 11 on the add-on calendar.
Your Honor, when we finish with courtroom 2, can we please do position 5 and 6? And then I will go and take the ladies back and bring the others back. Please. And thank
Okay. Okay. So let's see. I'll do Mr. Williams.
Yeah, here he is. Judge.
Okay, and what are we doing with Mr. Williams this morning?
Mr. Williams would like to enter a plea this morning.
Okay. Good morning, Mr. Williams. I'm Judge Eric Marr. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you, sir. Yes, Ms. Faulkner.
Yes, Your Honor, the state's recommendation on this case is 12 months probation, serve 18 days, credit for time served 9 days. That's going to be from March 11th to March 19th of March 11th to March 19th of 2024, 40 hours community service, DUI risk reduction, victim impact panel, $300 fine, and ADET. As part of this plea agreement, the state is going to null cross position 11. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
We do stipulate.
Anything further, Ms. Vigilante?
Yes, Judge, just briefly, although, the state will null cross the FTA, I did just want to state for the record that Mr. Williams was incarcerated, on the date of his hearing, January 16th in Rockdale. I was also just wanted to ask this morning, because he has been incarcerated for the past 10 months, it's going to take him some time to reestablish employment, and he has probation here as well as in Rockdale. I did want to ask the court if you would consider waiving the first few months of fees to give Mr. Williams a chance to get a job and start to be able to pay for these probation expenses.
Okay. Mr. Williams, it's my understanding in case 23 CR 006093J, you wish to plead guilty to DUI, less safe. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Williams. I'll waive 2 months of probation fees to help you get and stay on your feet. Also, when you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation and won't have to pay those fees, okay?
Yes, Your Honor.
Thank you.
All right. Good luck to you, Mr. Williams.
Next, we have position 5 and 6 on the add-on calendar, Destiny Esober.
Are you ready for Destiny?
Okay, where are we? Here we go.
And what are we doing with your client this morning? Mr.
Your
McClain?
Honor, is this add-on 5-6?
That's correct.
Okay, we're in a quandary. We're kind of at a standstill on this. The interview was refused yesterday, and I don't have, at the current time, I haven't had enough time to discuss fully. I have been on the phone with her today, which is not quite making up for the refusal to interview yesterday.
You need a reset, Mr. McClain?
I think it's gonna need to be a 2-day reset. I'll go to the jail and talk to her face to face and see if I can get her to understand the court system better.
Okay, we will have her as an add-on for 321.
Thank you.
Okay, we'll see you.
So sorry, Your Honor.
Ms. Falk?
I was just going to ask PD McLean if he had seen my note about MMHC.
I did, and we will definitely be addressing that.
Okay, I would appreciate it. Thank you, because I believe she would be a good candidate.
I do too, if there would be commitment, yes.
Understood.
Judge, apparently the victim is on the line for this case. I don't know if anybody want to address her or not.
Okay, is that Julie Ross?
Yes.
Okay, Ms. Ross, this case is going to be reset until Thursday, so we'd be happy to have you back on Thursday, okay?
Okay, thank you so much.
You're welcome. You have a good day, ma'am.
You too, thank you.
Who do we have next?
Oh, by the way, while we're going through the calendar, Your Honor, there were two people that had been that are in Cobb County Jail, and I have announcements. On the regular calendar, Mr. Hayes, I have two Mr. Hayes today. The Mr. Hayes on position 5, that is a negotiated plea. Mr. Lewis on position 7, that's a waiver of presence and arraignment. Those are my Cobb people.
We can go ahead and go to position 5. No,
Okay.
And the deputy is telling me we can go ahead and go to position number 5 on the main calendar. Mr. L. Hayes, Hayes, just no relation to number 6.
Where is Mr. Hayes?
Right here, he's coming around to the chair, Your Honor.
Yes, good morning, Mr. Hayes. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Hayes. Ms. Falk?
Yes, Your Honor. The recommendation on this case is on position 1, 12 months served, 4 days, credit for time served, 2 days. That's from May 31st to June 1st of 2023. Balance suspended, stay away from the BP gas station. On count 2, we are asking for time served, 4 days, credit for time served, 2 days to run concurrent with count 1. I do want to place on the record that this defendant is currently in custody on numerous felony charges. He was not in custody on this case in particular, and so this will not result in his release from custody. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
For that purpose, we do so stipulate.
Anything further, Mr. McLean?
Nothing, Your Honor. Thank you.
Mr. Hayes, it's my understanding that in case 23 CR 003437Y, you wish to plead guilty to criminal trespass and willful obstruction of a law enforcement officer. Is that correct?
Yes. Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir. Very.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do understand.
Has anyone forced or coerced you to plead guilty?
No, sir. No one has.
I'll accept the plea as negotiated, Mr. Hayes. Good luck to you, sir.
Thank you.
Thank you. Now, do we have Shaniqua Carter, number 3 on the add-on available from ACDC?
I think she's going to get additional people, Mr. McLean.
Oh,
We do have someone on the jail court's iPhone now.
I was going to say, basically, number 3 on the add-on is my other negotiated plea today. And everybody else pretty much looks like a not guilty.
Okay, well, let's go down through them one by one then. Who do we have at the jail court's iPhone?
We have position number 4, Mr. Floyd.
Curtis Floyd, number 4, is not guilty, Your Honor. I don't know that we wouldn't really need to have a reading of the accusation.
Would you like me to arraign him, Mr. McLean?
Yes, Your Honor.
All right. Good morning, Mr. Floyd. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Okay. Can you raise your right hand for me, Mr. Floyd? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can place your hand down, sir. Mr. Floyd, you've been charged in case 24 CR 001047F with battery family violence. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding that you're waiving formal reading of the accusation, Mr. McLean.
Yes, Your Honor. I think the maximum fine on that would be 5.
Okay, how do you plead, Mr. Floyd? Guilty or not guilty?
Not guilty.
Towards your not guilty plea, your case will be returned to the division judge and you'll get notification of your next hearing date. Your client has a question, Mr. McLean.
It's probably something I can handle by the telephone. Is there a phone where you are, sir? Do they have a phone? Call this phone?
Could I speak?
Well-
You have a right, Mr. Floyd, you have a right to remain silent. Anything you say can be used against you. Mr. McLean, if you would answer any of his questions after court today, I'd appreciate it.
Thank you, Your Honor, yes.
Okay, so Mr. Floyd, Mr. McLean is gonna call you after court today, and he'll answer any questions that you can have, okay?
All right. Next, we have position on the probation calendar, position number 4 and 5. This is Mr. Edward.
Mr. Edward. Yes, that's Ms. Vigilante. She'll be right with us.
Okay, good morning, Mr. Edwards. I'm Judge Eric.
She has stepped away, Your Honor. I could handle probation 8, 9, 10, 11, 12, and 13, 14. But
Okay, well, if we can't take Mr. Edwards, let me go back to courtroom 2 and ask them who they'd like for me to take next.
We have position number 2 and 3, Earl Crosby.
yeah, 2 and 3 is Earl Crosby, and he is not guilty. He'll come up here, Your Honor. Your Honor, I don't think there's any need for us to have a formal reading of the accusation. We could waive that.
Okay, good morning, Mr. Crosby. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducted by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Mr. Crosby, you've been charged in case 22 CR 0080005J with reckless conduct and dog at large. Each of these charges carries a maximum penalty of 12 months in jail and or $1,000 fine. It's my understanding that you're waiving formal reading of the accusation, Mr. McLean?
Yes, Your Honor, we understand the charges, so we'll waive that.
How do you plead, Mr. Crosby, guilty or not guilty?
Not guilty, sir.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, Mr. Crosby.
Thank you, Your Honor.
Next, we can do position number 7, Now Lewis.
Your Honor, Mr. Lewis and I, he's from Cobb County. I interviewed him this morning, and on that, we can file a waiver of presence and arraignment. I have his permission to sign his name on the form over there.
Okay, as such, Mr. Lewis's case will be returned to the division judge and he'll get notification of his next hearing date.
Thank you, Your Honor.
Okay.
Good to meet you.
Who do we have next?
The probation counselor, we have position number 1, Alan Gregory.
Probation 1. Gregory.
Good morning, Mr. Allen. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you, sir. Let's see. Ms. Allen, are we ready?
Yes, Your Honor. Mr. Allen, he failed. I'm sorry, here, echo. Mr. Allen failed to pay the probation supervision fees of $147. He's failed to pay the fine of $1,355. The defendant has been in custody since March the 11th. It's 3 months, 22 days remaining on his case. At this time, probation recommends his case be time served.
Any objection, Ms. Vigilante?
No, Judge.
All right, time served. Good luck to you, Mr. Allen.
Thank you, sir.
Next, we can go to position number 2 and 3. Odini Brown.
It's also on the probation calendar.
Judge, can I speak to Mr. Brown for just one moment? I haven't talked to him yet.
Okay,
It's fairly straightforward, but this is just one moment. Thank you.
you're fine, Ms. Vigilante. Let me know when you're ready. Mr. McLean, do we have any of your clients that we have not yet seen that are in courtroom two? If so, we can move on to your case.
Who we have in the courtroom physically with me is probation 8,9, probation 10,11, probation 12, and but probation 13, 14 is going to be the ACDC.
Okay, so can we take somebody that's in courtroom two that's your client while I wait on Ms. Vigilante?
Position
Yes.
8 and 9.
Here comes 8 and 9, whose name is Mr. Kemp, K-E-M-P. He is in agreement with the recommendation we were told.
Good morning, Mr. Kemp. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Good morning, sir. Yes, Ms. Allen.
Mr. Kemp failed to report to our office, failed to complete the anger management course, as well as pay his probation supervision fees. It is 7 months, 3 days remaining on his case, and at this time, we recommend that defendant be allowed to continue on probation and enroll within 30 days upon release.
Mr. McLean?
Your Honor, I'm going to give him a sheet of paper on which to write his phone number, address, email if he has one, and emergency contact. He tells me he would love the chance to prove himself on probation. He appreciates it being a second chance.
What's the problem, Ben?
That's a good question, Your Honor. Let's ask him directly. But why did you fail probation?
I just got homeless at the time. I got homeless.
Speak up. You got homeless at the time.
I got homeless at the time, Your Honor. And
Okay.
That'll do it.
Do you have a place to reside at the present time, Mr. Kemp?
yes, sir. I got
Okay.
I have a place, sir.
Okay, very good. All right, so I'll let you continue on, Mr. Kemp. Good luck to you, sir.
Yes, sir.
Sooner you get this done, sooner you can get it behind you, all right?
Yes, sir.
Can you sit up there and win chair? They don't like these fans going back there. They say, Jacob. We're not saying.
We can go to position 10 and 11. Norwood Gerald.
Good morning, Mr. Norwood.
Yeah, say good morning.
Good morning, Your Honor.
If you needed to talk to him, Mr. McLean, I'll give you that opportunity.
No, I was just telling him, Your Honor, that Your Honor is probably going to want to hear an explanation as to how he messed this probation up. He is in agreement with the recommendation of the probation department.
Mr. Norwood, this is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you, sir. Ms. Allen?
Mr. Norwood failed to complete 10 community service hours. He failed to report to probation. I don't have the amount of time he's been in custody at this moment, but probation does recommend for his case to be time served.
Any objection?
No objection.
All right, time served. Good luck to you, Mr. Norwood.
All right, good luck.
Next, we can go to position 12,
Stephen Perkins.
Stephen Perkins.
Okay, good morning, Mr. Perkins. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Ms. Allen?
Mr. Perkins failed to complete 50 community service hours. He failed to pay probation supervision fees. After review of his time remaining on his case, probation recommends that his case be time served. He's been in custody since March the 11th of 2024.
Any objections?
No objection, Your Honor. We'll note that recommendation. Time served, no objection.
Served. Good luck to you, Mr. Perkins.
Okay.
That's all for Mr. McLean and,
That's everybody in here.
and we can go back to Ms. Vigilati's client, position number 2 and 3.
Okay,
I'll double check. I'll double check.
Can you come sit over here for a minute? Does this is Mr. O.Z. Brown?
good morning, Mr. Brown. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you, sir. Ms. Allen?
Your Honor, the defendant failed to pay restitution in amount of $100. The defendant failed to pay the probation supervision fees. He failed to report to probation. He failed to complete the shoplifting course. And he also failed to appear for his revocation hearing or compliance hearing. At this time, probation recommends for this defendant to be to continue on probation.
Ms. Vigilati?
Yes, Judge, I spoke with Mr. Brown, and at the time, and he continues to be residentially challenged. He did, just recently complete treatment at Trinity House, which he successfully completed, between, needing to go to residential treatment and some issues he was having with Social Security income. I mean, he just told me that he was overwhelmed and he lost track of his probation, but we've discussed everything required of this probation. We're making a plan. We're actually speaking with Tia Burgess, the social worker here, to make a plan to get some stable housing that allows him to complete the requirements of probation. And I think we're on the right track. And Mr. Brown would happily go back on probation, have a chance to finish that out correctly. I did want to ask today, because he is having ongoing trouble with housing and income, if the court would be willing to a few months of probation fees to give him a chance to get his Social Security sorted out before he has to, pay. He has a significant amount of money to pay between the restitution, the fees, and of course paying for the course. So yeah, if you consider giving him a little break on probation fees, help him get some stability. I think we're working on a good plan here for Mr. Brown to be more stable going forward.
How long has he been in custody?
Mr.
Since
Brown,
February 6th. He's been in custody since February 6th.
I'm sorry, Ms. Allen, tell me again what he still has to do while he's on probation.
Your Honor, and actually, I just realized he has 2 cases with our office. Only one case has a warrant on, and it looks like he's required to complete the shoplifting course. He's also required to pay restitution in the amount of $100. And on his second case, he's required to pay restitution in the amount of $809.12 and stay away from the victim in the incident location.
But he's only here on that first.
Yes, Your Honor.
Taking.
That's correct, Your Honor, because the second case, he was sentenced to probation February the 20th.
And I'm sorry, Ms. Vigilante, does he have employment at the present time?
He has retirement. He's having an issue with his Social Security checks, but I think once he gets those resolved, it'll go a long way to help with housing. He's had a very long ongoing issue. He's missed the past 16 payments which has, of course, greatly contributed to his housing needs.
And what is the restitution for, Miss Allen? Do you know?
Yes, Your Honor. Give me 1 second. The victim is Margaret Bender.
Okay. All right.
Mr.
Go
Brown
ahead.
has told me what the restitution is for. If you'd like
Okay.
to- it was an Amazon package that had a pair of workout shorts and some plates in it.
All right. So, Ms. Vigilante, I just don't want to set him up to fail. You know, I know he's, if it weren't for the restitution, I would be inclined to have him be done. But given that, you know, there is restitution, and I believe that the victim should receive that, I will continue him on probation as suggested by Ms. Allen. But if we can make sure that we get him some housing, if we can assist him with housing, I will waive 2 months of the probation, ongoing probation fees to help him get on his feet. And hopefully we won't see him back. Okay, so Mr. Brown, I'm going to give you the opportunity to continue to get this done, and I hope not to see you back. Okay, sir?
I'll make it happen, Your Honor. Thank you for helping.
All right. Good luck to you, sir.
Next week, number 4 and 5 on the probation calendar.
Okay. Good morning, Mr. Edwards. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Let's see, who's representing Mr. Edwards?
Ms. Vigilante will be right with us, Your Honor.
Can we do position number 6, Tyrone Hayes, medical?
Represents, is that your case, Mr. McLean?
Did you say 6 on the main calendar?
Yes, Tyrone Hayes.
Yes, Your Honor. That's ready.
Okay. Good morning, Mr. Hayes. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Where is Mr. Hayes? Is he on?
Is that going to be jail courtside phone? Not a very large image there.
No, that was medical. I think they got disconnected somehow.
Okay, they're medical. They get disconnected. And also I have Gus McKinney on number 9, if he's available.
Do you have anyone that's at ACDC? Mr.
I
McLean?
have Laverne Woods, who is a probation case.
Yeah, it seems like medicals have some technical difficulties.
Okay, we'll come back to medical. I see Officer Milton coming, so we'll be with Miss Woods. Thank you. Good morning, Miss Woods. Can you hear me okay?
Yes, sir.
Yes, good morning. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Miss Allen?
Ms. Woods, she failed to complete the domestic violence counseling. She failed to report to probation. She also failed to pay her probation supervision fees. She has been in custody since March 6, 2024. It's 35 days remaining on her case. Her case was reset from last Thursday. Probation at this time recommends for her case to be revoked.
Mr. McLean?
Your Honor, this doesn't speak directly to why she failed to do correctly on probation. But we must note that she has some serious medical issues right now, and it is related in that sense. She has lost a kidney, she's on disability, income, she has pre-diabetes, and she's been having some medical difficulties. These have been distracting to her. She has family in Atlanta. She has 2 uncles who can make sure she stays on the straight and narrow path. She would like to ask the court to give her time served and forgive the 35 days remaining. And she is remorseful that she did not finish it correctly.
How long has she been in custody, Ms. Allen?
Since March 6th, since the 6th.
Okay.
Oh, I wrote something down here. I just now figured out what my writing meant there. She has a slow heart rate. So she does have a heart condition.
Okay, I'm gonna give her credit for the time that she's been in. It'll be time served. Good luck to you, Ms. Woods.
Thank you.
Thank you, Your Honor.
Your Honor, it looks like that she also received first offender, which the court still be willing to give her a first offender.
Well, I'm not so inclined to give her first offender if she didn't do anything.
Okay. All right, thank you.
Well, it wasn't that she didn't do anything. She didn't finish completely. She says that she did pay fees, but I haven't gotten receipts yet. But she does say she paid fees.
Well, she didn't do the main thing, Mr. McLeod. She didn't do the DVIP, which is probably the main reason that she's on probation.
That's correct.
So I don't think that paying the fees for supervision when you're not actually doing anything, that's the reason for you being supervised, that you should get any credit for.
Understood. Understood.
Who do we have next?
Next position is Ms. Marks is position 8 on position 8. Brianna Marks.
Oh, that's the one where I have tried to call Ms. Fox from the desk phone, but it's not letting me. So what I'm going to do, Your Honor, is take my cell phone, go over to medical records section, and get right by the window where there's some good reception, and I'm going to try Ms. Falk from there.
Or you could just be placed into a break. Is anybody else in the courtroom with you? Can I just place y'all into a breakout room? I don't
That's
think that we
fine.
have anyone.
That's fine for the state.
Yeah, that's
I have
fine.
one-
Okay, all
I
right.
have one more.
Well, we're not going to be able to do anyone else, and so I understand you have one more. Let me place Ms. Falk and Mr. McLean into a breakout room, and then I'll get back with you, Officer Milton. Okay.
Okay, thank you.
All right. So if we could place Ms. Falk and Mr. McLean into a breakout room, and the court will be in recess until they return.
Your Honor,
Yes.
while you be taking this break, I'm going to run down to the floor and get one more person for the first appearance calendar.
Okay. Thank you, Officer Milton.
Your Honor, the state and PD McLean, what? Okay, I left him in the breakout. He should be headed back our way. But just to put on the record for Your Honor, we did discuss potentially placing Miss Marks in a treatment court. So PD McLean is going to explore that option, and we would like to reset it to Thursday so that he has an opportunity to find out if they would accept her in that program.
Okay, thank you, Ms. Falk. I appreciate it.
Hey,
What
good
position
afternoon.
was this?
Good morning. This is Officer Blunt. I have an announcement. Position number 9, Gus McKinney. He's gonna be a medical reset.
Okay, so we'll reset him for 3/21.
But I have a position number 6, Hayes.
Okay, let me have courtroom 2 get back with me, and we'll be with him.
Excuse me, Ms. Falk, who was the person y'all said you guys considered? What position was that considered for mental health court?
That was, well, it's not mental health court, no, but that was Brianna Marks, and that's position 8.
And y'all resetting it to Thursday?
Yes.
Can we pull courtroom 2 out of the breakout room, please?
Oh, there's courtroom 2, Your Honor.
And
Okay.
we'll mention mental health court on the misdemeanor level also as a potential possibility. We'll explore both in the next couple of days.
PD McLean, the only reason I would not recommend MMHC is they will not take her because she's currently on felony probation.
Oh, okay, that would be a disqualification. Understand.
Okay, so Mr. McLean, position number 8, Ms. Marks is being reset till 3/21 Thursday. While you were away, I don't know if you heard, but position number 9, who I believe also is your client, Gus McKinney, is being reset till Thursday, a medical reset also.
Very good, Your Honor. Thank you.
All right, so who can we go to next?
I think that's maybe everybody for me.
Okay, is Ms. Vigiletti there ready to proceed on any cases?
Let's see what you got.
Yes, Judge.
Okay, so who do we have at the jail, on the jail court's iPhone?
We have position number 4 and 5 on the probation calendar, Mr. Juan Edwards.
Yes, and this is your case, Ms. Vigiletti?
Yes, Judge.
Yes, good morning, Mr. Edwards. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Yes, Ms. Allen.
The defendant failed to complete the domestic violence intervention program. The defendant failed to appear for for a compliance hearing on May 4th, 2023. It's 4 months, 26 days remaining on his case. He has been in custody since August the 27th of 2023. At this time, probation recommends that his balance be revoked.
Ms. Vigiletti?
Yes, Judge. Mr. Edwards has been in custody for 206 days, which is close to 7 months. And, you know, this probation violation seemed to just pop up in the system as his felony case was being resolved and he was getting ready to leave the jail. And so we are requesting today for the 7 months that he's done to be considered in the revocation and for him to be receive time served today. You know, had we known about this case 5 months ago, we would have brought him before you 5 months ago, and then he would have completed his time. In the alternative, if the court would consider putting him back on probation, I did speak with Mr. Edwards yesterday. And he did proactively ask me, you know, he understands that the Family Violence Intervention Program is 6 months. He understands, you know, why probation is asking to revoke the time, it makes sense, but he did proactively ask me, well, could I do some community service? You know, is there something else I can do to prove my time, on probation if I can be reinstated on probation? And so, you know, primarily, of course, I'm asking the court to consider the 7 months he's already served to count towards the revocation and make this time served. But in the alternative, Judge, if you're willing to consider putting him back on probation, he is motivated and interested in doing something to prove his time on probation.
Okay, I would rather him do something than nothing, Ms. Vigiletti, and he doesn't have time to do the DVIP. I will consider converting that to 12 weeks of anger management and continuing him on probation. He's to report as scheduled, so I'm going to give you that opportunity, Mr. Edwards, to at least be able to do something. So I'm going to convert it to 12 months of anger management, but I want you to make sure that if you don't report or if you don't begin the anger management within, I'll say, the next 2 weeks, then I'm going to have probation bring you back, and at that time I'm going to revoke, but I'm going to give you the opportunity to make it right, okay? Yes, sir.
Can you just make sure that I get proper information on what a report to this time?
I'm gonna bring it up to you right now. I'm gonna bring you everything in writing that we just said, so there's no more confusion, okay? So as soon as court's over, I'm gonna come up and see you.
Okay, thank you.
Okay, and Ms. Allen, how often is he supposed to report at the present time?
As long as he stays in compliance, he will report once a month. If he's not in compliance, he will report every 2 weeks.
Okay, so and by your next report date, Mr. Edwards, I want to make sure that you have begun the anger management. If you have not begun the anger management by your next report date, then Ms. Allen, I would request that probation bring him back so that at that time I can consider revoking the balance. Okay?
Okay.
Good luck to you, Mr. Edwards.
Thank you.
Your Honor, that concludes my business. May I be excused?
Yes, thank you, Ms. Allen. I appreciate everything this morning. Have a good day. Okay, who do we have in medical?
Number 6.
And this is Mr. Hayes.
That is our other Mr. Hayes, Tyrone Hayes.
What are we doing with Mr. Hayes this morning?
Yeah, he's a not guilty, Your Honor.
Would you like me to arraign him, Mr. McLean, or are you gonna file a waiver?
I can file the waiver if it's okay with Mr. Hayes. We did discuss that. Mr. Hayes, is it okay if I sign your name to a waiver form?
Yes.
Okay.
Okay, as such, Mr. Hayes, you'll get notification of your next hearing date. The case will be returned to the division judge. Good luck to you, sir.
Thank you.
Okay, do we have anyone at ACDC that we can take?
Yes, Your Honor, we have, I believe they're all Mr. McLean's clients, Ms. Carter Anderson and Ms. Marks.
Right, on Ms. Marks, we made an announcement, Brianna Marks.
Okay, Ms. Marks is being reset until Thursday. And who was the other one?
Brianna, I'm sorry, Miss
Carter Anderson.
Carter Anderson, it's a hyphenated last name.
Position 3 on the add-on calendar, Your Honor, and position.
Thank you, Ms. Clark.
Ms. Carter Anderson, please come forward and have a seat.
I knew it was somewhere.
This is a negotiated plea, Mr. McLean.
It is, Your Honor.
Good morning, Ms. Carter Anderson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? You're on mute, Officer Melton.
Good morning, Your Honor.
Yes, good morning, Ms. Carter Anderson. And my question was, do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, ma'am? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you. Yes, Ms. Falk.
Yes, Your Honor. The state's recommendation on this case is for 12 months served 16 days, credit for time served 8 days. That's from March 11th to March 19th. Stay away from Fado's Irish Pub located at 933 Peachtree Street in Atlanta, and that's on count 1. Count 2 is going to be 12 months served 16 days, credit for time served 8 days, concurrent with count 1 with the additional condition of no further contact with Jenny Goodwin. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We would like to sound for Jenny Goodwin, and this would be a balance suspended plea.
If Ms. Jenny Goodwin is on the line and wishes to address the court, now is your opportunity to do so. Mr. McLean?
I believe that she is ready to go forward, Your Honor. For the purposes of the plea, we do stipulate to the elements as named by the state.
And Ms. Carter Anderson, it's my understanding that in case 23 CR 007039C, you wish to plead guilty to theft of service and simple assault. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay. I'll accept the plea as negotiated, Ms. Carter Anderson. Good luck to you, ma'am.
Thank you. Thank you.
Balance.
And Your Honor, the state has submitted a null pros on position 4 of her case, the FTA.
Okay, thank you, Ms. Falk. See, do we have anyone else that needs to be addressed that we have not? Position number 9 on the add-on calendar, have we done that?
Judge, that is Blake Kennedy. I have attempted to speak to Mr. Kennedy, multiple weeks in a row now. He refuses to come to the interview booth. It's my understanding he might also have a pending eval. So he may need to be reset for the 11 a.m. calendar.
The 11 a.m. calendar on Thursday?
Yes, Judge.
Okay, so Ms. Lewis?
Yeah, this case was reset from the last week. There was an add-on from last SAP. So you're asking to be reset for what day?
For Thursday for mental health issues, I believe.
Yeah.
Okay, I haven't seen an eval done yet on this case. Are you planning on submitting it? And can we set it out further for the eval to the following week?
Mr. Bartles told me that the doctor came multiple times to try to do the eval and that he's refusing to work with the doctor as well.
I was just trying to see if we can do it to next week, the 28th, copy C counter, if that's what you're trying to get it on. The other one is already sent out.
And
I mean, I'm just asking, would that be a problem to set it next Thursday, copy C counter?
I mean, it's not a problem for me. But I also don't have any, I don't work on competency, so.
all right, when would you like it reset until? I guess, I think Ms. Lewis is saying that she can't reset it till this Thursday. Would there be an objection to setting it for the following Thursday?
I certainly don't have an objection. He hasn't spoken to us for several weeks now, so I think probably that will continue, so.
Okay, so we can do that, Ms. Lewis.
Thank you, Judge.
Oh, okay, and so addressing in the chat, Miss Wesley, you were here on Tyrone Hayes. Mr. Hayes, his attorney filed a waiver in the case. The case is being returned to the division judge, and notification of a next hearing date will be sent out. Ms. Falk, I believe that she is a victim, alleged victim in the case. So if your office could reach out to her.
Your Honor, I'm already communicating with her
Oh.
in the chat, so I will just let her. I did let her know what Your Honor just announced, and I'll give her some more information.
Thank you, Ms. Falk. All right, and there's also on position 12. Has it been transferred to the DA? I have DA transfer.
Your Honor, the state did request to transfer to the DA's office. We have not received a response yet. However, given that this case does involve a recidivist that we were able to show his entire recidivist history was out of Fulton County, we don't believe there is any reason why it will not be accepted. There's just been a slight delay lately of getting the response back and getting the motion signed.
Okay, so it doesn't fall through the cracks, Ms. Falk. Let's set it a week out.
That's fine, and the court has done that, and we've been able to get the orders by then and submit them.
Okay, so I believe that is that the 26th?
Yes.
And please remember, this is a cyber jail case, so you won't actually see the paperwork in the system because this case has not been initiated yet in the system. I made notes on the counter, let y'all know that.
Understood. Could I make a request when we do get the order signed so I can forward it to the clerk's office in the felony division, and it can be assigned a CP number? When the orders are signed, could I have them sent back to me stamp filed so I can go ahead and send them to the felony clerk?
I can do that. As long as you send them directly to me, it will get done.
Okay, I appreciate it. Thank you, Ms. Lewis.
Okay, and just go ahead, Ms. Falk.
I was just going to say that's the same announcement on 12 and 13. So both are cases where the defendant is a recidivist, where the previous history is in Fulton County. I was able to send all of that to the DA's office, and I'm just waiting for a response. And we would ask for the same reset date.
All right, so on 12 and 13, we set to 3/26 as well. Does that take care of everyone on our calendars this morning?
Your Honor, I believe there was a DBBW for Cedric Smith at 11.
Okay, I didn't receive I don't have a bench warrant calendar.
Good morning, Judge. This is Cedric Smith.
Let me see, Judge, I'm gonna send it to you, but let me double check. It should have been with the rest of them, but I'll send it to you right quick.
Thank you.
Mr. Smith, we have a few minutes before 11 o'clock starts. We got 10 minutes. Would you please call a phone number 404-612? What is that number? 2392.
Give it to me one more time, sir.
404-612-2392.
2392?
Correct.
Yes, sir. I'm about to call it right now. Thank you, sir.
Pretty sure that's it.
Ms. Falk, I'm sorry if I missed it, but position 17, was that a successful DA transfer? Or do we need to reset that one as well?
That actually was a successful transfer. The DA transfer paperwork was submitted to Judge Law on March 14th. I did resubmit that for signature, and I just need a copy of the signed stamp filed order.
Okay, thank you.
Your Honor, I also have an update on Jeffrey Sparrow, which is position, hold on, let me just find my, yes. We did receive an email back from the litigation manager saying that the case will be added to the next available jail jury trial calendar. I will try to ascertain, I will respond and try to get a date certain, but that is their indication.
Thank you, Ms. Falk.
Hey, Your Honor,
Yes, sir.
can I speak to him again? He told me the number's 404-612-9392. It said invalid number.
I don't think that's the number. One second, let me get the number here.
Yes, ma'am.
So, Your Honor, with that being said, on position 14, would you still like to reset that to March 21st? Or I can forward you the response from Miss Lucas if Your Honor needs to see that.
Mr. Smith,
Yes, ma'am.
try 404
Okay,
12
okay.
391.
We'll see if we can get.
The phone broke up. You said 612?
2391.
Yes, ma'am. Thank you.
Yeah.
When they turn the phones back on in this courtroom after the break, they switch the numbers, so. It's ringing.
Okay, I'm sorry, Ms. Falk. Tell me again, who we were talking?
Oh, I was just stating that given that information, I can send Your Honor the email from Miss Lucas, the litigation manager, and Judge Edie. But given the information that I just provided in the update, I was just asking if Your Honor still wants to address this on March 21st, and that's position 14, Jeffrey Sparrow.
Right, no, so they're gonna address it, right?
That's correct.
Okay, so
I did respond and ask them to see if they could give me a date certain, but they did say they are going to place it on the jail jury trial calendar.
okay, that's fine then. We'll just let them handle it.
Okay.
So it's just reset for the notice back to the case manager for Judge Edie then, for position 14?
That would be correct. That they did state they want it and they want to place it on the jail jury.
And let's see, okay, they're gone now. All right, as we wait,
Yeah, Mr. McLean is speaking to Mr. Smith right now.
okay, so I'll wait for him. We'll do the bench warrant calendar and then we'll go over the calendars.
Sounds good.
Your Honor, just to get a update, because I don't have a announcement for number, and I may have just missed it, number 16, Jalen Thompson.
Oh, yes, Judge, I'm sorry. I meant to mention this. So Mr. Thompson had court downtown for a felony today. And so we're requesting a reset to Thursday, because he couldn't come to both at once.
Okay, so it's reset for Thursday, 3/21.
Possible, thank you.
Yeah.
Ready to proceed, Mr. McLean?
Yes, Your Honor.
Okay, let's see, it's Mr. Smith back with us. There you go. And Ms. Falk, oh, Mr. Graham?
Your Honor, I can handle this one. There's kind of some additional information I need to give the court.
Okay. Go ahead, Ms. Falk.
Yes, Your Honor. This is a bench warrant case where the bond is in forfeiture status. I do want to point out that Mr. Smith, this is not his only case currently in our office. Additionally, he has, excuse me. Let me just pull that up because I was looking at his other cases as well, one of which is in FTA status. Let's see. So currently he has 3 cases before this court. He has this case that's on the calendar, which is the simple assault, family violence, simple battery, family violence, and criminal trespass dated May 20th of 2023. On that case, the bench warrant was issued on, let's see, the bond was ordered forfeited on February 16th of 2024. And the defendant failed to appear on July 3rd of 2023. That was when the case went into dormant case status and a warrant was issued and the bond was ordered forfeited. The arrest warrant was then voided August 3rd, 2023, with a note to the file that said the defendant would come out and fill out a case reset form, but then was later forfeited on February 16th of 2024. So that's case number 1. There are 2 other cases that are on the calendar, not on the calendar. One is 22 CR 006964E. That case, the defendant failed to appear at arraignment on July 3rd of 2023. And that current case is in FTA status, but the bond has not been forfeited at this time. There is a third case for criminal trespass, which is 23 CR 005644E. That case is currently set to go to arraignment before Judge Morrison on March 22nd of 2024. I believe, let me just double check, that all 3 cases are currently before Judge Morrison. And given that the defendant is in FTA status on one of these cases and is in bond forfeiture status on another, we are asking that the court not lift this bench warrant and that he have to appear on his open cases before Judge Morrison on March 22nd of 2024, when he is scheduled to go to arraignment on the criminal trespass case.
Ms. Lewis?
Ms. Falk, just a correction on case 22 CR 006964E. That case is not in bond forfeiture status. This is the only one bond forfeiture status. Bond forfeiture was set aside because I guess they changed up his address. That case is not in bond forfeiture status and it's not a new court date assigned to it. Only one in status is this one on the calendar, and then he has a schedule. But that one was not in bond forfeiture status. It was set aside. August 30th of 2023.
Okay, Ms. Lewis, 6964E, I am showing that there was a failure to appear July 3rd of 2023. You're saying that was set aside?
Yeah, that was set aside. Yes, it was, but it was set aside. You indicated that it was still active. It's not. It's set aside.
So my apologies. I thought that was still an active bench warrant. So then there is only one bench warrant, which is this one, but we would still ask the defendant to go before Judge Morrison on the 20, let me get this date again, the 22nd to address all 3 cases.
That's Friday.
That is correct, Your Honor.
Okay, Mr. McLean?
Your Honor, what I'm noticing is that I wrote them down as A, B, and C. And if the bond forfeit, if the failure to appear on July 3rd, 2023 in the case ending in 64E was set aside, we're talking about something where the failure to appear date is the same date. And I'm assuming it would have been the same place. So it would be logical to think that if missing court on July 3rd, 2023 for a case ending in 64E was forgiven, it would make sense to forgive the misstep on this case in which the failure to appear is also July 3rd, 2023. And I assume it was in the same courtroom. However, let me mention this. He was in jail and then he went homeless and he told his bonding company, Alpha, that he was going to be homeless and asked them if they could get the mail and inform him of his next court date. And they later had to apologize. They said, you know, they couldn't get hold of him or they didn't try or something like that. That was a total misstep. That was total sliding on a banana peel, thinking that it was a skateboard. So that was a mess. And he and I discussed how you don't rely upon phone calls, you go down in person. You know, the public computer on the counter at the clerk's office that we used to talk about in court, that computer is now gone. I've been down there. So you have to go to the window and talk to a live person. You can't just walk in there, look up your own name. But now that he came to the clerk's office and gave them his correct address, there shouldn't be any problem. And of course, if he's got a court date on Friday, if he's supposed to be somewhere on Friday, he's going to be there.
And Your
Okay,
Honor,
and no, I'm just saying, the FTA was before Judge Morrison, the one that we're here on today? Yes?
yes, Your Honor. And the key difference here is on the other case, he missed arraignment on July 3rd of 2023 and apparently was able to rectify it. On this case that's on the calendar, there was arraignment on July 3rd, 2023, and then it was reset for February 16th, 2024. And it was on February 16th, 2024 that they forfeited the bond, which means that he didn't appear for two different arraignments, which is why his bond was forfeited February 16th of 2024.
Well, it's my inclination that since he has a court date before the same judge that he FTA'd in front of, that I'm going to think that she should handle, and especially since it's on Friday, that she should handle all of his cases at that time. Now, Mr. McLean, has he already made application for your services of the public defender, or y'all representing him? If not, it sounds like he'll qualify.
Yeah, I don't believe he has. He is temporarily unemployed, and I believe he would qualify at this time, but I don't believe.
Okay, so why don't we have him make application for the public defender so that you all will have somebody representing him at that calendar on Friday? Can we do that?
Yes, Your Honor. I'll find out who do they take the odd or even. Miss Lewis has something, I think.
I do. To Ms. McLeod represent him on the other battery case. She represent him on the SEA counter as a conflict attorney.
So that's Maureen McLeod, and so
yes.
I shouldn't have even been talking to her.
Well, no, not this case is not Marlene Cloud, but the other one is.
I understand.
But I know normally y'all give all three. Well,
okay, so let's have Ms. McLeod represent him on this case also, and then she can represent him on Friday at the hearing for all of his matters.
I will encourage Mr. Smith to call Ms. McLeod, and if he doesn't have her number, I can have her call him.
Okay. So that's what we'll do. All right. So Mr. Smith, Mr. McLean will be in touch with you. You'll be represented by Ms. McLeod, and hopefully you can straighten all this out on Friday. Just make sure that you attend. Just make sure you attend that hearing.
Yes, sir. I'm gonna be there. Yes, sir.
Oh,
one question.
okay.
One question, Judge. So
Yes,
they're gonna
sir.
try to handle all of them in one time, and they happen differently, or how would that work?
Well, you're before the same judge on all of these charges.
Okay.
And apparently you failed to appear before on one of her calendars. So given that her calendar is on Friday, I think it's best that she handle everything at one time, so to clear everything up for you, okay?
Okay, so what do I need I could start? So my understanding, so at my bond at forfeit, what I need to do is just go down there on the 22nd.
Well,
Right.
to answer all these questions, Mr. Smith, it's best for you to ask Ms. McLeod. And do you have her number? If you don't have her number, call me back at 91-2391.
Okay.
I'll get her in touch with you. I can't promise that I can give you her number straight out. It's her cell phone, but I will
Yes, sir.
get you two together. I will get y'all two together.
All right, thank you, sir. Yes, sir.
Did he know what time his court day is for Friday?
Yes, man, I got it. I got my paperwork inside.
You got your
Yes,
notice? Okay,
yes, man, I got my paperwork.
all right. Just
All
wanted to-
right.
And I do need to clarify your address, because you do have different addresses on record. And I
Yes,
think the
ma'am.
Confusion was,
You ready for it?
yeah, what is the correct address? Just let
Did
me
we
know
do
if
that
it's the
in-
one, just let
Are
me know
we-
if it's the one in
Are we
the.
still in an open court, or should we do that on chat or
No,
not?
I just need to know if it's the 3639.
Yes, ma'am, that's it.
I mean, is it 3639? No,
I'm trying to 3939. That's it. Yes, ma'am.
Okay, that's the one I just need to know. Okay,
Yes, ma'am.
all right.
Okay.
And Your
All
Honor,
right. Yes, Ms. Falk.
I am sending an email now to the litigation manager, Ms. McLeod, and the SG team in front of Judge Morrison to let them know that we are asking that all three cases be addressed on Friday, March 22nd. And the defendant did appear in court and stated he would be present in court on Friday.
Very good. Thank you, Ms. Falk. All right, so if nothing further, Mr. Smith, you're free to go, sir. And Ms. Lewis, whenever you're ready, I think that we've completed the calendars for this morning. So whenever you're ready to go over them.
I'm ready. I'll start the probation revocation calendar.
Thank you, Your Honor. Sorry about that.
No, have a good day, Mr. Smith.
Yes, sir.
Position number 1, Gregory Allen was commuted to time served. Position number 2, Mr. Brown was reinstate probation, waived 2 months of probation fee. Same now for 3. Position number 4 and 5 was Mr. Edwards, was reinstate probation, convert his domestic violence class to 12 weeks English management, must enroll within 2 weeks and report weekly to probation. Position number 6 and 7, Mr. Hawkins is revoked 4 months and 28 days. Position number 8 and 9, is that correct? I thought I heard something. Okay. Position 8 and 9 is reinstate probation. Defendant must enroll in the VIP program within 30 days of release. Position number 10 and 11, Mr. Norwood is commute to time served. Position 12, Sam Nassett, Mr. Perkins is commute to time served. Position 13 and 14, Ms. Woods is also commute to time served. That's it for the probation revocation calendar. For the add-on calendar, position number 1 is set for the notice. The case is has an amended bond for $2,500 SOB for pre-trial level 1. And I'm supposed to get that from the private attorney for that case. Number 2 is going to be set for the notice. Position 3 was a plea. Position number 4 was non-pros. Position number 5 is and 6 is going to be set for the SAP counterpart. Thursday, 3/21. Position number 7 was a plea. Position number 8 was non-pros. And position number 9 is going to be set to the competency counter for March the 28th. Position number 10 was a plea. Position number 11 was non-pros. Position number 12 is to be set for the SAP next week, March the 26th. That take care of the add-on counter. Any questions? Okay. We're ready for the original counter. Position number 1, defendant was released. The case is reset for the notice. Position number 2, defendant was arraigned not guilty. Case is reset for jury trial. Further notice. That's part 2 and 3. Position number 4, defendant was arraigned not guilty. Case is reset for jury trial. Further notice. Position number 5 was a plea. Position number 6, defendant waive arraignment not guilty. Case is reset for trial. Further notice. Position number 7, defendant waived their present and arraignment not guilty. Case is reset for trial. Further notice. Position number 8 is going to be reset to the add-on calendar for this Thursday, SAP, March 21st. Same announcement for number 9 is going to be added to the SAP calendar for March 21st for medical reasons. Position number 10 is reset further notice. Defendant is released. Position number 11, defendant waive arraignment, not guilty. Case is reset for trial. Further notice. Position 12 is reset for SAP next Tuesday, 3/26. Position 13 is reset for SAP 3/26. Position number 14 is going to be returned to the original Judge Edie for trial. Further notice. Position number 15, defendant is released. The case is reset. Further notice. Position 16 is going to be on the add-on calendar for this Thursday, SAP for March 21st. Position 17 is transferred to the DA. I do have that transfer order, time of Judge Law. Position number 18, it was a plea. Any questions or corrections or concerns, or do I need to go over anything else?
Ms. Lewis, do you mind sending me a copy of the order signed by Judge Law on Walding, please? Thank you.
Okay, it's scanned in the system.
Oh, great. I didn't know if this was one that wasn't able to be uploaded. So
No,
that's
it was, yeah, it's attached. That's how I ended up getting it.
I appreciate it. Thank you.
Yeah, no problem. I think I got all your NAR process. And I think I'll just be waiting on the plea paperwork. I thank y'all.
Thank you.
All right. You all have a good rest of your day.
Thank you, Your Honor.
All right, thank you, Judge. I'll
See
get
you
the
next
paperwork
time.
to you as soon as possible.
Okay, if you get them to me before 2, I'll get them before the SEA calendar. If not,
I'm gonna try my best. I hope the PDs heard that.
okay.
On my way to the office.
All right, we'll see y'all
Okay,
next
all
time.
right, bye-bye.
Bye.
Thank you.